Section 1192A. Operating a motor vehicle after having consumed alcohol, under the age of 21, per se for people younger than 21, having a blood alcohol content, BAC, as low as 0.02% can lead to stiff penalties, so a single drink may be enough to trigger state sanctions. Vehicle and Traffic Law Section 1192A establishes this strict standard by making it illegal for an underage motorist to operate a vehicle with a BAC between 0.02% and 0.07%. It is a per se offense, no proof of impairment is needed, and it is treated as an administrative matter rather than a criminal case. Drivers whose BAC measures 0.08% or higher, or who show signs of impairment, may still face criminal DWI or DWAI charges. Enforcement starts with a lawful stop. Police must have a valid reason to pull a car over and cannot rely solely on the driver's age. If an officer smells alcohol or sees signs of consumption, they may conduct field sobriety tests and use a roadside breathalyzer. A reading of 0.02% or higher allows them to detain the driver for a certified chemical test, which must be performed within 2 hours of driving. If the confirmed BAC is within the 0.02 to 0.07% range, the driver is charged with violating Section 1192A and usually surrenders their license on the spot. The penalties are serious. A first violation leads to a 6-month suspension of the driver's license and a $125 civil fine, plus a $100 fee to reinstate driving privileges. A second offense within 5 years, or any subsequent alcohol-related violation, results in a 1-year revocation or a revocation until the driver turns 21, whichever is longer, along with the same civil penalty and reapplication fee. The Department of Motor Vehicles may also require an alcohol education program or an ignition interlock device when a higher BAC is involved. Cases are handled through a DMV Administrative Hearing rather than criminal court. To prove a violation, the state must show by clear and convincing evidence that the driver was under 21, operated a vehicle in New York, had a BAC between 0.02% and 0.07% from a properly administered chemical test, and that the traffic stop was lawful. If any of these elements are missing, the hearing officer must return a not guilty finding and the license is reinstated. Because the standard is high, thorough preparation can make a difference. Young drivers do have defenses. They can challenge the legality of the stop, argue that the test was not conducted within 2 hours, or question whether the testing equipment was maintained correctly. The law is not violated when a confirmed BAC reads 0.00% or falls below the threshold, even if the officer smelled alcohol or obtained an admission of drinking. Procedural mistakes, such as failing to follow proper paperwork, can also lead to dismissal, and drivers have a limited right to appeal. Navigating these issues alone can be difficult, which is why consulting a lawyer who understands DWI cases is important. A seasoned attorney knows how to challenge questionable stops and unreliable tests and can represent you at the DMV hearing. Even when a violation appears likely, having a lawyer by your side may reduce the impact by ensuring that any penalties are applied correctly and that you meet the requirements to regain your license. A zero-tolerance violation can affect more than just your ability to drive. It may influence college admissions, employment prospects, and insurance rates. The Kugel Law Firm helps underage drivers and their families understand their rights and pursue the best outcome. If you've been charged under 2A, contact the Kugel Law Firm at 212-372-7218 or visit 111 E 125th Street 2nd FL, New York, New York, 10035 to discuss your options and protect your future.